$1,000 reflects the entire March and April rent, as if you didn't pay anything in March and April. What happened to January and February? Does that mean the landlord's demand is defective? Does that mean that the landlord can't get the rents that you withheld in January and February? Well, the answer is no. Rent payment is always applied to the earliest arrears. That means that all the partial rent payments you made went to pay January and February. I know that this can cause confusion, especially when you're trying to keep track of whether the landlord is crediting all the payments you made over a long period of time. For that purpose, you should plan to ask for a payment history showing what was actually paid and when. It should look like this chart here. Then you can match the rent history with your checks and money orders. If the landlord's printout is confusing you, then you should just take a clean sheet of paper and make your own rent history. When the dispute goes back over a year or two, making your own rent history is an absolute necessity. Can a rent demand include late fees or legal fees? Well, some courts have ruled that other charges other than rent should not be included in a rent demand, but most courts presently hold that a late charge or a legal fee can be listed separately on a rent demand, but it cannot be included as additional rent. So, while it's unclear whether additional charges renders the demand defective, it is something to raise when you're getting advice. What about the rental rate? Is that correct? In a rent-stabilized or a rent-controlled apartment, the landlord is not allowed to charge more than the legal rent. This should be checked with your DHCR rent history early on. If you are being overcharged, this case is an opportunity to counterclaim for a refund of illegally charged rents. Who signs the rent demand? The demand can be signed by the landlord or the landlord's attorney, unless the lease specifies that the notice can only come from the landlord. Now, if the rent demand is sent by an attorney, an additional law applies. This is a federal law entitled the Fair Debt Collection Practices Act. According to this law, an attorney who regularly does non-payment cases must notify you in writing that you have 30 days to dispute the debt. This federal notification should appear on the 3-day notice, or it can be sent to you in a separate notice. If an attorney fails to give you notice that you have 30 days to dispute this debt under the Fair Debt Collection Practices Act, the landlord's attorney may be liable for damages. Again, these are all issues to be raised when you go and seek advice on your case. In the next turn of the road, your landlord will serve you with a notice of petition and petition. The notice of petition and petition are usually 2 sheets served together. They're often printed along the long side. As shown in our graphic, within 5 days, you're supposed to take this paper down to the court to file an answer. This is an essential piece of paper to present to your attorney or housing advocate because there are always defenses lurking in the petition. Many of them are related to the defenses we just went over in our discussion of the 3-day notice. But the most common defense to a notice of petition is whether the landlord properly served it to you, or whether he served it to you at all. The service, that is, the means of delivering the notice of petition to you, is called process service. Even if you knew about the action, if the landlord's process service did not comply with the law in every respect, the landlord's case will be dismissed.
Hi, my name is Luis Ayala. I'm a Latin singer in a Latin band. Between the gigs, I'm a process server licensed in the state of New York. A process server is the person who delivered paper from the court to the people, strictly accordance with the CPLR rules.
I'm a process server and some documents to be served. Thank you.
It's an important job because if the process server served a petition wrong, the case can be dismissed. The preferred way of serving a person is to deliver the paper or giving the paper personally. You've been served.
Okay, but the party that you wanted to serve isn't here.
Steve, the person was somebody of suitable age.
But I'm not of suitable age.
Oh, how old are you?
13.
Traigo una bomba pa' Malaika y Asisa. Traigo una bomba sabrosa. Ay, this is the second time I try to serve this paper. What is it? So bad is home. Don't hear nobody. I have to put the time in my affidavit. The second time is 4:10. I record the time and date on my official log every time I attempt a service. I may have to show this to the judge in a hearing. Well, nobody here now. What I'm gonna do, I'm gonna tape the petition to the door and then I'm gonna mail it because that's the rule under the CPR. Now I go to the office to make my affidavit and mail it to them. Some lazy process server will file an affidavit of service stating that they were at your apartment when actually they didn't go. What you do in that instance, that would you always check out the affidavit of service. The process service has to be correct in every respect. If not, the landlord case can be dismissed.
Landlords are terrified when tenants bring up defective process service. I've overheard landlords outright lie to mislead tenants in order to drop their process service defenses. Also, if you have defective service in your answer, many landlords will just settle your case on the spot rather than go through the trouble of a hearing. The worst is when the process server never actually tried to serve the papers and then lies in the affidavit simply to make a quick buck. And then the tenant might be safe from an eviction because the clerk sends a postcard informing the tenant of a court case. This happens a lot and it's completely unacceptable. To review, let's go over the requirements for process service.